All right, let's go ahead and get started. Welcome. My name is Wendy Venderlo. I'm the Executive Director of NAPSA. It's my pleasure to be with you here today, and I'm very, very excited for you to hear this information about the webinar we have today. Just a couple of housekeeping bits before we get started. We will have some information at the end. We have upcoming webinars that are scheduled, and so toward the end, I will talk about that in addition to talk about some changes that we have going on at NAPSA, including new software and a new website that'll be rolling out in the next month. And also the fact that we have a special election going on right now. So if you haven't heard from me, kind of be looking at your emails and looking at the website because we have information about that. And I'll talk about that at the end. But otherwise, as far as this webinar goes, basic housekeeping stuff, the chat is enabled. So that you're able to talk with one another and talk with the facilitators here through the chat. But I ask you, please, if you have any questions for our speakers, to please put those in the Q&A. It just is a whole lot easier for us to monitor and make sure that we are answering your questions effectively. So again, please put your questions in the Q&A. But with that, it is my extreme pleasure to welcome our guests today from Loyola University Center for Criminal Justice, Drs. Olson and Dr. Steeman. And so I'm going to turn things over to them.
Thanks, Wendy, and thanks everybody for joining us today. We want to thank the National Association of Pretrial Service Agencies for giving us the opportunity to share some of the research that we've been doing, evaluating the implementation and impact of Illinois' Pretrial Fairness Act. What we're going to talk about today is a little bit of an overview of the framework of the law, and then findings from our research on the implementation of the new policy and the impact that it's having on justice system operations and outcomes. I'm joined today by my colleague Don, so we'll be trading off at different parts of the presentation. To start, I wanted to give everybody just a little information about our center. The QR code on the screen, if you go to that, you can go to our website, sign up for our newsletter. We put that out every couple months, and through that newsletter is how we make people aware of new research findings that are emerging from this research as well as other research that we're doing. Don and I co-direct the Center for Criminal Justice at Loyola. It was formally established in 2015, so we're celebrating 10 years of doing policy-relevant research in collaboration with practitioners and policymakers. Our center has a number of full-time staff, but we also have a number of graduate and undergraduate students that collaborate with us on this research and other research in the center. So if you're interested in following us, you can go to that QR code. I'll bring it up at the very end of the presentation in case you missed it then. So we'll get into the discussion about what work we're doing and how we're going about doing this evaluation. So just a little bit of general information about how we're going about evaluating the implementation and impact of this reform to the pretrial process, which we'll be describing in more detail. We've got a grant from the National Institute of Justice to do this research, and we've also got a grant from the Arnold Ventures and the MacArthur Foundation to support the research, as well as resources from Loyola University to do this study. It started out as a 4-year evaluation. I think it's going to end up being a 5-year evaluation because the law's implementation was delayed by about 9 months. So in order to have a sufficient post-reform follow-up period, we're going to be carrying this research out until the end of 2026. In terms of the research methods, I won't go into a lot because I recognize that this isn't a research methods webinar, but I just want you to understand the depth and breadth of the methods that we're using to fully understand how this law is being implemented. We are doing a number of methods. We're using surveys and interviews and focus groups to obtain information directly from practitioners and policymakers. We've also been doing interviews with justice-involved individuals who've gone through the pretrial process, both before and after the law. We've done court observations, and we're collecting and analyzing a lot of administrative data. The research design is a pre-post test design, so we are studying what pretrial practices look like before the law, and then how do they look after the law, and how much of those changes can we attribute specifically to the reform that we're going to be talking about. For some of the research, we're trying to do the research on a statewide basis. So there are some sources of information that we have from the entire state, but we're focusing on 33 of Illinois' 102 counties for some of the more in-depth aspects of the research, such as the focus groups and the interviews, and also obtaining data directly from the local jurisdictions. There's 102 counties in Illinois, and that'll be an important point a little bit later on when we start talking about implementation, because it is a very diverse state. The map on the left is just highlighting which of the counties in Illinois are among those 33 that we're focused on. If you're not familiar with Illinois geography, up on the upper right of the map is Cook County, which is Chicago. So we're looking at how the law is being implemented in urban areas like Chicago and some of the surrounding suburban counties, as well as larger, more urban counties outside of the Chicagoland area, as well as jurisdictions that are primarily rural jurisdictions. And part of that is we want to be able to speak to how the law is being implemented and its impact across a diverse set of communities. For the research, we're also collaborating a lot, obviously, with the elected and appointed officials in the local sites where we're working, but we're also working with some state-level agencies to get information about jail populations, and we've been collaborating with the Office of Statewide Pretrial Services, which was created in, I think, 2022, and serves about 85 of the 102 counties in terms of providing pretrial services. So we'll get into a little bit of the framework of the law and then start talking about what we're finding from our research. So one of the headlines and what most people think of when they hear about Illinois' pretrial reform is the elimination of cash bail. Throughout the presentation, we're going to refer to the law as the PFA, or the Pretrial Fairness Act, just for brevity's sake. But that's the most obvious change that Illinois has implemented. There is no longer cash bail that is used under any circumstance for a defendant to secure pretrial release. Prior to the law going into effect, around $140 million each year was collected statewide from defendants and their families for the purposes of securing their pretrial release. Of that money, a portion of it, roughly 10%, was allowed to be kept by counties in Illinois as an administrative fee. So counties collectively got about $14 million a year from these bond processing fees. The rest of the money was primarily used to pay fees and fines and restitution. Then a small amount of that money was returned to the defendants. Obviously, under our current law, judges are still able to impose fees and fines and order restitution. The difference now is there is not a pot of money from what was posted for bail to satisfy those financial conditions. So for a lot of people, it's the elimination of cash bail that's the headline for the law. But the Pretrial Fairness Act also dramatically changes the pretrial process in Illinois. One of the things it does is it restricts which cases can be detained pretrial. It also requires much more substantive hearings in order to detain somebody or in order to impose pretrial conditions on a defendant. And the law also requires that defendants have legal representation at pretrial hearings. And that's a change that makes Illinois unique among most states, in that it statutorily now requires defendants to be represented at pretrial hearings. What I'm going to try to provide in this overview is just a little bit of an understanding of the framework of the law and how the new law operates. Probably one of the uglier graphs or visualizations that we've ever made, but trying to squeeze a lot of information in here to provide a little bit of insight into how this works. So up at the top in the blue text are a list of what crimes people are charged with that are eligible for pretrial detention in Illinois. And so if you follow the blue boxes in the diagram, Those are those people charged with a detainable offense. In the yellow are people who are charged with non-detainable offense, which is the majority of people arrested in Illinois are not charged with an offense that's eligible for detention. Importantly, as you follow this schematic, individuals who are arrested for a detainable offense or for a non-detainable offense can be booked into a jail and held in jail before they appear before a judge for either the setting of pretrial conditions or for a detention hearing if they're eligible for detention. But for those who are charged with non-detainable offenses, there's also the option under the law where police are allowed to give an individual a citation with a future court date in lieu of arresting them. But that's up to the discretion of local police departments. After someone's been booked into jail, if that's the outcome, they have to appear before a judge for a conditions hearing. So if the state is not seeking to detain an individual who could be detained, they would go to a conditions hearing. So that blue and yellow line leading from booked in jail pretrial is the path that individuals can take. But if the state's attorney does want to seek detention, then a detention hearing would be held. And after that detention hearing, there's a number of options that we'll get into, and we'll kind of describe what the numbers are showing. They could be held in pretrial detention. They could be released with pretrial supervision or with other conditions, or they could be released with just standard conditions. One of the important things about the law, and we'll talk about this a little bit later when we talk about what we're seeing in terms of some of the impact, is individuals that are released pretrial, either with supervision or with just standard conditions, if they fail to appear for a subsequent court hearing, or if they're charged with new criminal activity, they can be detained either for a brief period of time if they fail to appear, or they can be detained for the duration of their criminal case, even if they weren't originally charged with a detainable offense. So individuals who are initially charged with a non-detainable offense can end up being detained pretrial if they violate their pretrial conditions. I'm going to turn it over now to Don, and he's going to talk through a little bit more detail about what we're starting to find in our evaluation in terms of how this law has changed the practices within the court.
Thanks, Dave. Yeah, as Dave pointed out before, one of the things that the law tries to change is the content of conditions hearings or detention hearings to try to make that decision more, or the decision-making process more substantive, more thoughtful than it was before. What we did was look at bond hearings or bail hearings that occurred before the implementation of the Pretrial Fairness Act, those hearings in which a judge was determining how much money to impose and essentially detain a person for, if anything, for a short period of time before they could make bail. And we compared those hearings to detention hearings that occurred after the implementation of the PFA, those hearings in which a judge was determining whether or not to detain someone pretrial. The easiest way that we can think about whether these hearings are more substantive after the law is just to look at how long it takes a judge to make that decision, whether to impose bail or whether to detain a person after the implementation of the PFA. Before the PFA went into effect, bond hearings took anywhere from 3 to 4 minutes. They were relatively short. Judges made those decisions quickly. What we saw after the implementation of the PFA, in those instances where judges were determining whether or not someone should be detained pretrial, the hearings were taking much longer, 3 to 4 times longer than they were before the implementation of the PFA. In some counties, the median time that they were taking to make these decisions was upwards of 30 minutes. We've observed hearings that took 45 minutes to an hour. But in all of the counties where we were observing court hearings, the detention hearing was taking significantly longer than it was before the implementation of the law. The other thing that we noticed when we were observing court was what prosecutors, defense attorneys, and judges were talking about when they decided to detain someone. So before the Pretrial Fairness Act, when bond was being considered, you can see from this chart, if you just look at it quickly, there's a little overlap in what prosecutors and defense attorneys were talking about. Prosecutors focused primarily on the current charge that the defendant was facing, sometimes prior convictions and the victim. Defense attorneys were primarily focused on community ties that the defendant had and their employment and education. And judges were providing very few reasons for the decisions that they were making. However, after the implementation of the Pretrial Fairness Act, two things happened. One, there was a lot more diversity in the factors that both prosecutors and defense attorneys were discussing. And two, judges were providing reasons for their decisions to detain or not detain an individual in almost every case. The one interesting thing we noticed was there was a lot more discussion after the Pretrial Fairness Act around strength of the evidence or weakness of the case in both prosecution, defense, and the judge. That's partly due to the decision making that has to occur in this detention hearing. One of the first things that judges have to determine is whether there's probable cause that the defendant actually committed the crime. That happens in this initial hearing, so there's a lot of discussion about the evidence. So one of the things we take away from this is a lot more substantive hearings. They're taking a lot longer to make a decision to detain an individual pre-trial. The other thing that's important to note, and as Dave pointed out, one of the primary goals in the law was to ensure that defendants had counsel at these pretrial hearings. So what you're seeing here is looking at rural counties and what percent of cases had a defense attorney at the initial detention or conditions hearing. And you can see that before the Pretrial Fairness Act in those counties that did not have a full-time public defender, only 33% of cases before bail reform took effect had a defense attorney at this initial hearing. After the law went into effect, 99%, nearly 100% of the cases had an attorney present. Even in those counties that had a full-time public defender before the Pretrial Fairness Act, just 69% of cases had an attorney present at pretrial hearings. That again is nearly 100%. So we're seeing longer hearings, more substantive hearings, and more substantive discussion about the factors around detention and individuals having counsel at those initial hearings. One thing also that's important to note is there are differences across the state in just how frequently these detention hearings have to occur. So in most urban counties, detention hearings are happening at least 6 days a week. In large urban jurisdictions like Cook County, they're happening every day. However, in smaller rural counties, they're having detention hearings less than 1 day a week. And if you can see from this chart that Dave's about to show you, the red days are days where detention hearings occurred. And you can see in some instances there are entire weeks in this particular county where there were no detention hearings. In most weeks, you can see there's one at the most 2 days where they're having detention hearings. So you can see that even while in urban parts of the state, there's a necessity to have detention hearings every day of the week. In some smaller rural counties, it's enough to have them 1 day a week to handle the number of cases that they're seeing. As Dave pointed out earlier too, the PFA also restricts which offenses are eligible for pretrial detention, as you showed in that flow chart of how cases kind of progress through the system. There's a difference between detainable and non-detainable offenses. But there's a finer distinction than that too. So the one thing the PFA does, it restricts who can be detained, but it also requires states' attorneys to initiate the detention process with a petition to detain, which is a new part of the law. And it also requires a judge to actually make a decision to detain based on that petition filed by the prosecution. So there are really 3 types of offenses that we think about when we think about the Pretrial Fairness Act. There are a set of offenses that are detainable for a public safety consideration. That includes all non-probationable felonies, forcible felonies, most weapons offenses, and domestic battery and violations of order of protection. Any individual charged with one of those offenses can be detained based on a public safety consideration and a petition filed by the prosecutor's office. There's another set of offenses that are detainable for a willful flight consideration. That's class 1, 2, and 3 felonies in Illinois, serious felonies. But those offenses are not detainable under the public safety consideration. And then there's another group of offenses that are not detainable at all. So anyone charged with a class 4 felony, which is the lowest felony offense in the state of Illinois, and all non-domestic violence misdemeanors. Anybody charged with one of those offenses cannot be detained. So what we're seeing is a big difference across the state in, whoops, I missed that slide. So the decision to detain is based on a judicial determination. As I said before, the judge has to make 3 decisions in that detention hearing. One, that there's proof evident and the presumption is great that the defendant committed the offense. Once they make that decision, they have to determine whether the defendant poses a real and present threat to the safety of the community. And third, even if they find both of those to be true, they have to also find that there are no conditions that can mitigate the threat to the community. So if the person can be supervised in the community, then judges are supposed to or presumes to not detain the individual. What we're seeing, though, is that even with that, there are few, if we look across the state at defendants who are eligible for detention under the public safety consideration, in those instances, only about 26% of individuals are being detained. If we look at the black bar and the blue bar here together, you can see that about 42% of individuals who are eligible for detention under the public safety consideration are having a petition to detain filed. If we kind of think about the converse of that, 58% of individuals charged with detainable offenses don't have a petition to detain filed in their case. If we look at how this differs between, say, Cook County, which is the largest jurisdiction in the state, and the rest of the state, you can see there's a big difference between Cook County and other counties in the state. In Cook County, 69% of individuals charged with detainable offenses don't have a petition to detain filed, while in the rest of the state, about 46% of those individuals don't have a petition to detain filed. We're seeing very different rates of detention because of that too. In Cook County, only 18% of people charged with a detainable offense are actually detained, compared to 34% of individuals charged with detainable offenses in the rest of the state. Even that, though, hides the variation across counties. What you're seeing here is the percent of cases with a petition to detain. Again, these are individuals charged with offenses that are detainable under the public safety consideration. And you can see here that there's a lot of variation across the states. In some counties, as many as 95% of individuals charged with a detainable offense have a petition to detain filed, where in some other counties, it's less than 20% have a detention petition filed in their case. So when Dave said before there are 102 counties in Illinois, when people ask us how's this being implemented, we say it's being implemented 102 different ways. Every county is very different, both in their decision to file petitions to detain and in the actual detention after those petitions are filed. One of the biggest impacts I think that we've seen across the state is how those individuals charged with class 1, 2, or 3 felonies are finding their way through. Again, these are individuals who are those individuals who are not detainable under the public safety consideration, but could be detainable under a willful flight consideration. Detention is rarely sought for these offenses. We're seeing very rarely across the state do prosecutors file a petition to detain for willful flight. So this might be the one group of defendants where we're seeing perhaps the biggest impact of the reforms, since these individuals in the past likely would have had bail imposed. Now they're not having petitions to detain, and they're largely getting supervision in the community. And with that, I'll turn it back over to Dave to talk about how some of the changes over time have occurred in the use of detention.
Thanks. So what you've seen is how much variation there is from county to county, and it really does reflect the diverse nature of the local criminal justice systems in Illinois. Now that the law has been in place for 2 years, what we're also starting to recognize and see is not only is there variation across counties, but even within individual counties, we're starting to see some variation over time. And we'll give you a couple examples of how that can play out and what that looks like. So one of the examples that we want to kind of show you is how can the implementation of the law change when there's a high profile incident that occurs that results in people questioning the decisions of some of the criminal justice stakeholders. So what you're seeing on the screen, the bar on the left is the decisions to detain and the decisions to seek detention for individuals charged with domestic violence cases in DuPage County, which is a large suburban county to the west of Chicago. What you can see there is in the first 6 months of the law, 2/3 of the individuals who were charged with a domestic violence offense did not have a detention petition filed. The remaining third had a detention petition filed, and overall about 12% of all people charged with a domestic violence case were detained pretrial. Importantly, most of those domestic violence cases that are going through the courts in Illinois are misdemeanor level offenses. What happened in April of 2024 was a specific defendant was charged with a domestic battery case, did not have detention sought, and was released pre-trial, and then within a matter of a couple days ended up committing a homicide against the original victim. There was obviously a lot of visibility and backlash from that incident. What happened as a result of that is the state's attorney in DuPage County adopted a policy where they would seek detention on everybody charged with a domestic violence case. We're not reporting anything that isn't public information. This was all covered by the media, and his articulation of this new policy was also put out there in the public. And what you can see is prior to this incident, again, about 2/3 of cases did not have a detention petition filed. After this incident and the adoption of this new local policy, over 90% of people charged with a domestic violence offense in that county were having a petition filed. What you can see if you focus on the black part of the bar, overall, what percent of defendants are being detained didn't go up a lot as a result of the adoption of this policy. But it is obviously consuming a significant amount of court resources. As Don mentioned, these detention hearings do take a lot more time than the cases did under the cash bail system. But this is an example of where the elected state's attorney in these particular cases has decided that he'll let a judge make the ultimate determination about pretrial detention, and he won't filter out cases prior to that. So this is an example of a specific incident that can change the implementation of the law in a specific jurisdiction. Another example that we've got of how things can change over time can be what happens when there's the election of a new prosecutor in a jurisdiction. So as Don mentioned previously, in Cook County, under the previous state's attorney, detention was sought about 30% of the time. It was a relatively low rate compared to other jurisdictions in the state. There was a new election for a state's attorney, and one of the campaign promises that the new state's attorney made was that she would seek detention more often, and had specific cases where she felt detention should be pursued, including specific types of gun possession charges and other violent offenses. And what you can see here is the rate at which detention was being sought went from 30% of all the eligible cases in Cook County to 45% of the cases, which is now right around where the rest of the state average is. As a result of this change, we've also seen an increase in the percent of the cases that are, in quote, successful, meaning what percent of the time when a petition was being filed was the outcome of that detention hearing a decision by the judge to impose detention. And again, you can see a slight increase here. It could be that judges are also changing some of their decision-making as a result of the increased visibility of these cases. It could also be an increase in the resources put into these hearings by the state's attorney to provide more evidence and more information for the judge to make that decision. But as Don said, we could do these 102 different ways, and we'd likely find little quirks in each county where they've changed or shifted their implementation of the law. One general thing we found was that the first few months of the law, we tended to see detention being sought more often and imposed more often. And this was when the law was completely new to everybody. They hadn't figured out how this would actually look like in practice. And then after those first few months, we saw the rate of detention being sought and imposed go down a little bit. And that was across the state as a whole. So that's a little bit about the court processes that we've studied that have changed. The other thing that we've looked at is how this law has changed or impacted the size and composition of jail populations. For a lot of the advocates that pushed for the law, the goal was to reduce the number of people held in pretrial detention. Or if not reduce the number, at least change the composition of who is being held in jail to reflect those charged with more serious offenses and individuals who posed a threat to public safety, as was the intention of the law. When we look at what the impact of the law has been on jail populations, if we take Illinois as a whole and add up the jail populations of all the counties in the state, you see the trend in the graph here. So prior to the law going into effect, the average daily population of jails in Illinois for pretrial detainees was right around 15,000 on any given day. And then you see the date that the law was implemented in September of 2023. And immediately after the law was implemented, you see the number of people in jail drop to about 12,000 on any given day. So right after the law went into effect, we saw about a 15% drop in the pretrial jail population in Illinois as a whole. What you can see in the graph then is that the jail populations slowly started to creep back up to where they were only about 7% lower at the end of July of this year. So again, we're seeing some immediate impacts of the law and then some gradual adjustments or changes to the size of the jail population as a result of it. Again, though, we have to recognize that Illinois is a diverse state. When we look at jail populations across different types of jurisdictions in Illinois, here we're showing the trends in the jail populations in Illinois' rural counties, in Cook County, which is the black line, and then in other large urban counties, which is the blue line. What we've seen is that the drop in the jail populations in rural counties has been the largest, and the drop has been sustained in roughly the 2 years since the law was passed. So the rural county jail populations dropped 17%, and they remained at that lower level throughout the duration. In Cook County, again, the jail population fell, and the jail population then began to increase. At the end of July of this year, the Cook County jail population, the number of people in pretrial detention in Cook County, was actually higher than it was prior to the law going into effect. What this likely reflects are two dynamics. One is that individuals are being held in jail for a longer period of time because they can't post bail to be released. But what we're also starting to see now is people who are being admitted to jail not at the initial appearance when they're charged with a detention eligible offense under the public safety consideration, but people who are now being admitted to the jail and held because they violated the conditions of their pretrial release, either by missing court or by picking up a new charge. Part of the change in the Cook County jail population is also reflecting this change in the pursuit and imposition of detention as a result of the new state's attorney's policy and then judges imposing detention. In the large urban areas outside of Cook County, again, we saw a fairly large drop immediately after the law. And then at least in all these counties collectively, it appears to have remained at that lower level. We've done analyses looking at a number of individual counties that are consistent with these trends or show some patterns similar to that seen in Cook County, where their jail populations are now higher than they were prior to the law going into effect, which again is important to recognize the local implementation of this policy. So we've seen a fairly large drop in the pretrial jail population. That's the blue line on this graph. What we've seen that counters this reduction in the jail population is a dramatic increase in the number of people on pretrial supervision in Illinois. And so you can see a couple things with the graph. The first is the number of people on pretrial supervision in Illinois began to increase when the Office of Statewide Pretrial Services was created. And I'll touch on that in a bit, but part of that is that there were a lot of counties in Illinois that had no options for pretrial supervision. And with the creation of the Office of Statewide Pretrial Services, those counties then began to have that as an option. And you see that trends in pretrial supervision populations began to go up. And then after the Pretrial Fairness Act went into effect, we saw that increase continue and increase even more dramatically. The pretrial supervision populations now are about 33% higher than they were prior to the implementation of the law. With the implementation of the Office of Statewide Pretrial Services in August of 2021, you can see what the impact has been on the availability of pretrial supervision and pretrial services in Illinois. The map on the left, the blue counties, or the counties that are highlighted in blue, had the full complement of pretrial services. They conducted interviews with defendants, they performed risk assessments for the court, and they provided pretrial supervision if that was something that a judge ordered. The yellow counties in the left were those that had limited capacity, so they might have only done interviews or assessments, but not pretrial supervision. And then the counties in gray had none of those services. Obviously, what you can see on the right is now every single county in Illinois has the full complement of pretrial services. And again, a lot of that is because of the creation of this statewide agency that's serving more than 80% of the counties throughout the state. Part of the impact of this is been most felt in Illinois' rural jurisdictions. So this is looking at the trends in the jail populations in rural counties and the trends in the number of people on pretrial supervision in rural counties. And so you can see that before the creation of the Office of Statewide Pretrial Services and before the implementation of the Pretrial Fairness Act, there were more people held in jail pre-trial than there were people under pretrial supervision in the community. And that shifted after the implementation of the Office of Statewide Pretrial Services and the implementation of the Pretrial Fairness Act, to where now there's about a 2-to-1 ratio. For every one person in jail pretrial, there's 2 people on pretrial supervision. Some of the research that we've done kind of exploring the use of supervision more closely, including supervision that includes electronic monitoring, is one of the strongest predictors of who is placed on pretrial supervision is defendants who had pretrial detention sought, but the judge didn't impose pretrial detention, which to some degree is what we would expect. In those cases where the charges were serious enough to warrant consideration of detention, if judges found that they were potentially had committed the offense, there was this opportunity or this mechanism to safely release them with pretrial supervision. So that gives you a little bit of an understanding of how this law has impacted the courts, how it's impacted jails and pretrial supervision. I'll now turn it back over to Don, and he'll talk a little bit about what we're finding in terms of how the law has changed rates of failure to appear and new charges filed against defendants.
Yeah, one of the concerns around bail reform is the impact that it might have on failures to appear. The concern before the law went into effect by many was that a defendant not paying monetary bail had little incentive to show back up at court. So there's a concern around failures to appear and new criminal charges filed with a larger number of people being released. We have limited information about failures to appear and new criminal activity. What we do have is some information from about 22 counties where we're able to track failures to appear and failure to appear warrants after the law went into effect. So what you see here are one large urban jurisdiction and 21 small rural counties, and trying to look at what the failure to appear rate is within 6 months of release. So we have limited information. Again, we don't follow individuals for very long. So this is just looking at the first 6 months after a person is released, either on bond or ROR before the Pretrial Fairness Act, that's on the left, or after the Pretrial Fairness Act. So what you're seeing in the left-hand chart is overall failure to appear rates. This is just tracking whether an individual failed to show up for at least one court hearing during during the life of their case. And you can see in blue are the small rural jurisdictions. You can see that failure to appear rates dropped from 25% before the Pretrial Fairness Act to about 21% after the Pretrial Fairness Act. But in that large urban jurisdiction, they actually increased from 19% before the Pretrial Fairness Act to 25% after the Pretrial Fairness Act. What I'll say is we're seeing that with very specific groups of individuals, primarily those who are issued citations rather than being arrested and showing up in court. Those individuals tend to have much higher FTA rates after the Pretrial Fairness Act, and individuals charged with class 1, 2, or 3 felonies who are not detainable under the public safety consideration. On the right-hand side, you're seeing the failure to appear warrant rates. So this is where a judge found the failure to appear serious enough that they issued a warrant for the individual's arrest. You can see in those smaller rural counties, FTA warrant rates also declined from about 17% to about 13% and remained flat in the one large urban jurisdiction at about 10%. But when we look at different populations, we're seeing very different outcomes. So if we look at individuals who are charged with non-detainable offenses, here's where you see quite a dramatic change in failure to appear rates, primarily in that large urban jurisdiction where failure to appear rates increased from 21% to 31%. They also went up in the smaller rural jurisdictions from 28% to about 31% as well. What we're also seeing is a slight increase in failure to appear warrant rates for this population too, in the large urban jurisdiction from about 11% to 16%, but relatively flat in the rest. So again, these are individuals charged with offenses that are non-detainable under the public safety consideration. If we look at individuals who are charged with detainable offenses under the public safety consideration who are released, here we see quite a big decrease in failure to appear rates in those rural jurisdictions, and a very slight increase in failure to appear rates in the urban jurisdiction. And for failure to appear warrant rates, again, it's flat in the urban jurisdiction and a slight decrease in the rural jurisdictions. But again, those individuals charged with detainable offenses tend to have lower failure to appear rates overall than individuals charged with non-detainable offenses, and the warrant rates tend to be much lower as well. Sorry.
I just add one thing that I think is some important context. So you might be wondering, why would we see decreases in failure to appear rates for those in the rural counties? And again, keep in mind that some of those rural counties had no pretrial services during the pre-law period, and now they do have those. So some of those improvements might be reflecting some significant changes just in terms of pretrial practices and pretrial services that are available. Sorry about that.
That's great. When we look at I just have one more. When we look at new criminal activity, we don't see any change in new criminal activity. Again, we have limited information. This is looking at just at one large urban jurisdiction. And in that large urban jurisdiction, we see no change in new criminal activity for individuals released pre-trial, whether they're released for a non-detainable misdemeanor, a non-detainable felony, or an offense that's detainable under the public safety consideration. And again, these are things that we're going to continue to look at. This is a 6-month new criminal activity rate. Same with the FTAs. We're only looking at 6 months. And again, it's a relatively small group of individuals, those first set of analyses. Now that the law has been in effect for 2 years, we can have much longer looks at failures to appear in new criminal activity, which we'll continue to look at as we go forward. I'll turn it back over to Dave, who's going to talk a little about impacts on sentencing.
All right, so we're almost to the end of the presentation. The last thing that I wanted to share, and this is some recent information we've been looking at, in part because a lot of the hope of advocates is that if we change pretrial practices and change the rates of pretrial detention, that can have a longer term impact on the use of a custodial sentence for individuals who are convicted. So we've done some analyses looking at shifts in sentencing patterns before and after the law. And we focused on the least serious nonviolent felonies, which, as Don described, are primarily the non-detainable offenses. And so the analyses are fairly simple. They're evolving and will become more sophisticated, but at least it gives you a little bit of a sense of some of the patterns that we're seeing. So again, this is only people who are charged with class 3 and 4 felonies, which in Illinois are the lowest classes of felonies, and only people charged with drug law violations and property offenses. Again, these are not detainable under the public safety consideration of the law. And again, we're looking at some patterns regionally. And what the graph is showing you for each region is what percent of people convicted of these offenses received a prison sentence. And then the yellow bar is what percent received a prison sentence after the law had gone into effect. And what you can see pretty consistently across each region is the likelihood of going to prison has gone down during the PFA period compared to the pre-period that we examined. Again, part of this potentially reflects the impact of less pretrial detention for this population. Importantly, we've also seen a decline in the use of prison in Illinois for the last 10 years. So this may also just reflect a continued trend of less of a reliance on prison sentences for individuals convicted of these less serious felonies. In terms of some findings to date, and as Don mentioned, this is still evolving as we continue to update analyses and get a longer follow-up period. Again, for many people, the biggest takeaway is there's no more cash bail in Illinois. The hearings where decisions are being made about detention and release on conditions, as intended, these are much more substantive, and the defendants are being represented in these cases. Detention is being sought in less than half of all the cases that are detainable under the public safety standard. One thing I will note that I think is at least illustrative of how research can be useful in helping people prepare for policies. Before the law was even implemented, we were asked, and we collaborated with colleagues at the Illinois Sentencing Policy Advisory Council to try to estimate what percent of defendants would likely be detained. And what we predicted was roughly 30% of all people arrested for a detainable offense would be detained. And the reality is it's around 30% of people who are arrested and charged with a detainable offense are being detained. So we were able to fairly accurately predict the overall rate of detention by primarily considering what's the extent and nature of people's criminal histories and their rates of past failure to appear. So those were pretty good predictors and helped the state and local jurisdictions plan for the potential volume of cases that they would hear. We've seen a net increase in the number of people under pretrial custody and supervision. So when you think about all the people under some form of pretrial surveillance, that's gone up. Smaller share of them are in jail, and a larger share of them are in the community under supervision. We've seen some increased rates of failure to appear for some categories of offenses and decreases for others. And this is where it starts to get complicated. We think part of the reason why we've seen decreases for some groups is some changes in the availability or the capacity to provide pretrial supervision, but more importantly, to provide pretrial support and assistance to defendants. But we've also seen some increased rates of failure to appear, particularly for individuals who are being given a citation in the field by law enforcement rather than being formally processed and appearing before a judge to be released. And so some of the things we've seen and heard through our interviews and conversations is sometimes the citations provided by law enforcement are handwritten and very difficult to decipher. They're also given in the field when the defendant may not keep track of what papers are being given to them and things like that. So we're trying to dissect more about what is the reason for some of these increased rates of failure to appear. But again, we know which offense categories are driving this, and it's people that are charged with crimes that are not detention eligible. These are oftentimes, in quote, low-level property and drug law violations where individuals tend to have higher risk factors. And in fact, the people who are charged with non-detainable offense have an objectively lower risk when we look at the VPRA done on those populations compared to the risk assessment done on the detention eligible population. Right? One of the things that people are most interested in, we haven't seen any change, at least in the one large urban jurisdiction we've been able to do this analysis in fairly extensively, and that's new criminal activity hasn't changed among the released population. And importantly, it's lowest for the people charged with the offenses that are eligible for detention under the public safety consideration. Couple other findings that I think are important just to understand. A state law, it's a state law that's implemented locally. So there's a lot of variation from county to county in how detention is being sought and the degree to which it's being imposed. We've seen the biggest impact in rural counties in Illinois. A lot of the advocacy and push for this legislation came out of Chicago, but it seems as though the biggest impact of the policy has been in Illinois' rural counties. Their jail populations have fallen and remained lower. They've seen the largest gains in terms of legal representation of defendants at that pretrial stage. And they've seen a big increase in pretrial supervision, in part because of its availability now. There's also been an impact on state resources. So there is a substantial investment that's been made in the creation of this Office of Statewide Pretrial Services. In addition, not part of the Pretrial Fairness Act, but kind of occurring simultaneously was the recognition that there are limited indigent defense resources in counties across Illinois. Indigent defense is supported financially at the local level in Illinois, and so there's been an infusion of some state resources to provide additional support for the provision of indigent defense in rural counties. And most recently, this past legislative session, state law was passed that would create a state-level public defender agency, in part to address this disparity in resources and the availability of indigent defense across the state. So with that, I will stop talking. I'll put this back up in case anyone wants to use the QR code to go to our website or to sign up for our newsletter. And with that, we will be happy to take questions and see what questions Wendy has curated from the chat.
Well, there are quite a few, and I can just start at the top and read those to you. So thank you to everybody for putting the questions in the Q&A. So the first one we have up here says, how is your data and analysis being received by local legislative or political agents, such as judges, district attorneys, elected officials? So how's the data being received?
Yeah, I think we haven't had too many people yell at us. I think in all seriousness, I think for many people, they appreciate the regular updates. What we've learned, though, in presenting this is to recognize that each local jurisdiction is unique. And so we have had some people push back when we've made statements about jail populations going down, for example. And we've had sheriffs reach out to us and say, I don't know how you can say that. Our jail population's higher than it's ever been. And then we kind of clarify what we said, what we meant by it. But that kind of feedback is valuable because we have to recognize that everybody's experiencing this law differently. And if we say something that's contrary to their experiences or what they're actually seeing on the grounds, we can lose some legitimacy in that. So we really have refined that message that individual counties may be seeing things that look very different than this.
Okay, the next one is, other than the abolition of monetary bail, what is the biggest complaint regarding the PFA that you've heard from stakeholders? And this person indicated that it has been the detention net for them.
Yeah, I think there have been two. I think one is there has been some pushback about the detention not being wide enough so that the public safety consideration is limited based on what a person's charged with, not based entirely on their potential risk for public safety. So we've heard that more offenses should be included, or a different way of determining whether or not someone's detention eligible should be included. The other thing that we've heard is that it's often burdensome to put together the materials necessary to file a petition, and to counter that petition by both the prosecution and defense. So we're hearing that there's the time is not enough in many places to make the determination or to even have the hearings, because they're so substantive and long now, to have the hearings necessary to determine pretrial detention. So we're hearing both those things: a detention net that's not wide enough, and a process that's become more burdensome and time consuming and not possible all the time to file a petition in every instance that a prosecutor might want.
Yeah. The one thing we haven't heard is people saying we wish we could have cash bail back. Right? So that's not anything that we've heard in terms of changes to the law or going back to the quote old way of doing things. So I think for many practitioners, they do see the value of being able to definitively determine that someone will be detained, that there's not a guessing game as to how much the defendant may be able to post. But to Don's point, there's the feeling among many that there's people that should be eligible for detention that currently aren't under the law. I think part of that also is, as we said, that the people that are not eligible for detention tend to have higher risk factors. They have higher risk factors for additional criminal activity and missing court. But we have to remind people that the intention of the law was to prevent violent criminal activity and willful flight from prosecution. So I think for many, there is a frustration that there's people charged with low-level drug possession offenses that have substance use disorders that can't be held in jail. And in many of the communities, there aren't a lot of options for referral to services if that was even considered. So those are some of the frustrations I think that some folks are expressing.
I just want to reiterate that what Dave said. There is a bit of a paradigm shift happening here. There is no discussion about monetary bail in Illinois anymore. It's about how to make this system perhaps more effective or efficient, which I think is a sea change in the national discussion around monetary bail.
Thank you. Don, I think you had answered one of the questions. I think you had typed the answer earlier regarding the how long a detention hearing can take, how long a person can be detained before they go before a detention hearing. And so a person had put in the question, just wanted to clarify that it's 48 hours, and then the prosecutor has the ability to extend that an additional 48 hours was the question.
That's right. Within 48 hours, a person has to appear before a judge. And at that, if the person's charged with a detainable offense, the prosecution can ask for a detention hearing to occur and can ask for a continuance until that occurs. And that has to happen within 48 hours of that. So someone charged with a detainable offense could theoretically be held for 48 hours before that detention hearing happens. Someone charged with a non-detainable offense, though, has to have that conditions hearing within 48 hours.
Great. And then there's a question whether or not you are aware of, or if you know, how many people are on electronic monitoring under OSPS.
I think I know the number, but I don't know it precisely. It's I don't want to guess. The important thing is it used to be zero before OSPS was in place. So again, in a lot of counties they're serving, they had none of that before. And now I think it's up where around a couple thousand people across the state, which again, if you kind of think about that as the interim step between jail and pretrial supervision without any kind of GPS or electronic monitoring, that drop in the number of people in jail is likely offset by the number of people on electronic monitoring or GPS supervision. But we've been analyzing the data with OSPS. Again, the strongest predictor of who gets GPS are people that were charged with a detainable offense, had detention sought, but detention was not imposed. And cases involving domestic violence tend to have the highest rates, or they're most likely to have that ordered. But again, there's a lot of variation from county to county. There's some counties that kind of buck that trend.
Right. And then this is maybe another one that is more related, probably a better question for the pretrial offices themselves, but they're asking here whether or not pretrial services offers any voluntary services that might help defendants prior to their next court appearances, such as supporting them finding housing or treatment or food insecurity or things like that.
I think there's a couple ways to think about that. One is there's the ability for a judge to impose conditions of pretrial supervision. So there can be conditions related to getting an assessment for a substance use disorder, for example. There are some specific offices that provide more substantive support. I believe that's provided through kind of a separate grant. But part of the challenge is that, again, a lot of the counties that have services through the Office of Statewide Pretrial Services are rural. They're fairly sparsely populated, and they have very few community level resources. So I suspect that pretrial officers try to assist, but they're challenged with the limitations of what exists locally. I think part of what the implementation of the law has done is it's really raised the visibility of these issues and the conversation around access to supportive services in parts of the state that normally haven't been a lot of the focus.
Great, thank you. Just a quick reminder, we're going to keep going through questions, but I did put in the chat our survey feedback for this session. So please take a look there. And then at the end, when we're done with questions, I'm also going to put a couple more resources in the chat. So stay tuned for that. This next question is kind of long, so I'm going to do my best here. Let's see. When looking at cost savings from reduced detention without safety trade-off, the post-PFA stabilization of jail populations after initial drops and then expanded pretrial monitoring raised questions about net public safety efficacy. So that was a statement. If increased releases correlate with any uptick in localized recidivism or victimizations, even if not statewide, how should ongoing evaluations prioritize victim impact assessments and rearrest severity over aggregate crime stability to provide a balanced view of the PFA's protective capacity?
Yeah, I'll just say this. The new criminal activity stuff that we showed already is just very aggregate. It's just whether whether an individual release was charged with any new offense. The plan is to disaggregate that by what the new criminal activity is, to get at some of what this person's asking, right? Whether or not there are changes in new violent criminal activity. If so, what populations of individuals released is that pertaining to? Are there certain groups that have higher risk of new criminal activity, new person offenses than other groups? That's not reflected in what we're doing here, but the evaluation is meant to get down to that level. The difficulty in doing any of this is when we get very localized in Illinois, we're talking about very small communities with very few people released and very few new violent crimes. So it's hard to talk about it without talking about it sometimes in the aggregate at the state level, or at least in across counties. I don't know, Dave, if you want to add anything to that.
Yeah, when we've looked at, when we've kind of disaggregated the nature of new criminal activity, violent crimes are rare, right? So that's one thing that's important to keep in mind. The other is when we do those analyses in more detail, the important question is it any different than what it was previously? So if there's no change, then again, people can debate whether that produces a net public benefit if we're reducing pretrial detention and there's no change in new violent criminal activity. The other thing I'd add to that I try to point out when we talk about this is one of the easiest ways to reduce the rate of failure to appear in new criminal activity is to dispose of the cases more quickly. If you have a case that lingers for a year and has dozens of court dates, there's an increased likelihood that they'll miss a court date or that they'll pick up a new charge. So it's important, obviously, to focus on new criminal activity, but we shouldn't just stop once the pretrial period is over and say, now we don't care about new criminal activity, right? If people don't get charged with a new crime on pretrial supervision, but they do 6 months later because we had an opportunity to provide an intervention or support and didn't, that's also something that we need to consider. The other thing, I'm not sure if embedded in that was the idea that we're going to save money through the policy because of reduced jail populations. That I'd at least kind of push back a little bit on. We haven't seen any evidence of that, and I don't know if we'd likely see that occur, because when we look at Illinois as a whole, we've seen the jail populations go down. But in any individual county jail, the population drop hasn't been large enough for them to justify closing the jail, which is about the only way that most jails are going to save money. They're not large enough where they're going to close housing units or things like that. So I think many people argue that the law would save a lot of money through reduced jail use. I'd at least push back a little bit on that idea, at least in the short term, because jail budget and jail resources don't change because rather than 100 people, we've got 80 people, right? A little less food, a little less clothing, but staffing's the same. Everything else is the same.
Great. Thank you. So next question, based on the sentence to prison numbers falling, does this take into consideration the number of pleas offered or accepted for these type of cases too?
That we haven't fully dissected if that drop is because of the Pretrial Fairness Act or the changes to it. So the short answer is we haven't determined what's driving that. It could be a change in pleas. It could be the idea that many people have, and that's, well, if they were released pre-trial and they seem to do fine, then do we really need to incarcerate them? That was something that we heard in interviews before the law went into effect, is some practitioners said, well, if the person's released and they don't pick up any new charges, that might work in their favor, right? They'll have demonstrated that they can be in the community and not commit crime. Conversely, many said that, but if they fail, that's even more justification or reason to impose the prison sentence. So it's just the reason for including that is we get asked that a lot. Has sentencing changed? It has. Is it specifically because of the PFA and some of the mechanisms in there? That we haven't determined yet.
I think you just answered the next question, which was, well, actually two that are related to that, saying that do you think pretrial services, court reminders, and referral to community agencies, do you think any of that accounts for the lower prison rate?
It could. I mean, people's success on pretrial release likely factors into the decision. If they access services and can demonstrate to a judge that their behavior is changing, yeah, that would affect decision making. And the fact that more people are on pretrial supervision and being monitored and having reports provided back to the court, again, if they're positive reports, you'd assume that it's got to be beneficial to the outcome of their case.
Great. Next, For charges that are not detainable under the PFA, do you all have data around the amount of police officers that will write a citation versus detaining the person until the initial hearing?
We're looking to see who's going to blink first on the screen. I'll answer it quick, and then Don can chime in. It varies from jurisdiction to jurisdiction. There are some counties that we've observed where they don't give citations. They arrest people, they hold them in jail. If it's a Friday, they hold them in jail until Monday. They go before a judge, and the judge releases them with standard conditions. There's other jurisdictions that use citations a lot. So it really varies from county to county in how they're using this. In some instances, it's how they interpret the law. During some of the early implementation periods, we heard from some practitioners where they did not believe they could legally hold somebody in jail to appear before a judge if they were charged with a non-detainable offense. And so they weren't holding anybody, even though legally they could have. And then they realized that the law does allow them to hold someone to appear before a judge rather than just issuing them a citation. I don't know if you're going to add anything else, Don.
Yeah, I was just going to say in Cook County, we have seen an increase in the use of citations. So at least in one large urban jurisdiction, they're using citations more than they did before the Pretrial Fairness Act. It's hard to gauge that outside of a handful of jurisdictions, though.
A related question to citations here is, do you know if court reminders are provided for those who are issued citations? And I think that question resulted from the statement about how that's where the greatest FTAs had been occurring, was when a citation was issued.
Yeah, Dave, you can correct me if I'm wrong. The text reminder is an opt-in process here in Illinois. You have to opt into being reminded via text. And what we're seeing at that citation level, what we think might be happening is people are reluctant to give law enforcement their phone number at the time of the citation, which would trigger the text reminders. So there might be some reluctance on people to do that.
Yeah, there is the option for it. So on the, we've looked at it closely in Cook County, which is where we've really been able to drill down a lot in the FTA rates and the form. It is on the form. It is an option for the defendant. As Don mentioned, we suspect that many defendants might be less inclined to do that in that setting. Again, this is in the field. Under the old system, they would have, if it was a felony offense, they would have appeared before a judge to have bail set in a courtroom with an attorney standing next to them. And at that point, they might have been more inclined to opt into a text reminder, or their public defender would have gotten their phone number and done that. So part of what we suspect is the reason behind the increased rate of FTA for those particular types of cases is the process is changing in how they're being informed of the charges and the environment within which it's being done.
Great.
So I saw some stuff in the chat, about,
Yeah.
different jurisdictions are doing different things. And again, that's kind of I don't want to say the main finding, but one of the most important findings is it really varies from county to county for all these things.
Mm-hmm. Yes. Yeah. Thank you. Okay. There's a question about whether or not you've had any ability to look yet at outcomes by race, ethnicity, or other factors, looking at potentially disproportionate benefits or costs, that sort of thing.
A couple of things. We've done some detailed analyses of detention being sought and detention being imposed. And in those analyses, we haven't found there to be any kind of racial disparity in terms of who's having detention sought or imposed. It's really driven by the nature of the charge and the extent nature of the criminal history, which I get it that there's race issues baked into the extent nature of criminal history. One thing that we have looked at is the racial composition of the jail population. That really hasn't changed. So particularly in Chicago or Cook County, 90+% of the jail population was people of color. Before the law, it's the same after the law. Even though the numbers were fewer, the racial composition was the same. So.
Great. I have another long one that's got a couple statements first. And they're saying CCJ. Do you think they're referring to your analysis or your department? CCJ.
Center for Criminal Justice. That's our acronym.
Or the Council on Criminal
or the
Justice.
Council of Criminal Justice. Yeah.
Yeah, I was not, so anyway, they use that a couple times. It says in the CCJ's first year analysis, they reported no statewide increase in crime rates post PFA, attributing stability to structure released conditions. However, some folks are critical and note that aggregate crime data may mask pretrial specific contributions, and preliminary localized reports indicated elevated rearrest rates. Here's the question. What enhancements to CCJ tracking methodologies, such as defendant level linkage of pretrial release status to subsequent arrests for violent crimes, are required to definitively rule out PFA attributable risks to public safety rather than relying primarily on population level trends?
Part of the analysis is intended to link what we have with the court records that we have to criminal history record information maintained by the state police. That would allow us to look at any new arrest of an individual anywhere in the state. And with that, we could look at type of arrest, when it occurred relative to when they were released, and things like that. I think that's what they're getting at. That's the best we have, and the ability we have to look at new criminal activity would be whether or not an individual is rearrested, as recorded by the state police.
Yeah. So we will be looking at that. And the reason why we included that in our first year report is many people were saying that there's been a dramatic increase in crime in Illinois since the law went into effect. And so we were just seeking to determine, did that actually happen? Has there been an increase in crime? And what we found was there wasn't. We're careful in the report to say we're not saying that it's because or not because of the law. It was just to put out there, what is the data say about the levels of crime in Illinois?
And I think you already answered this, but in case I missed it, I just wanted to be clear. Another individual had asked about, have you been able to drill down on the rearrest rates, specifically those rearrested for violent offenses? I think you said that was coming.
Yeah, that's coming. Just and again, hopefully folks don't think, well, geez, they haven't really done much of their work. The difficulty of assembling data from 33 different jurisdictions, and getting that to the point where we can then obtain and combine with that their complete criminal history records is extremely time consuming and cumbersome. And so we've held off doing it because we want to make sure that when we do it, we have a long enough follow-up period with the law being implemented that we have the most current data, because it's an enormous undertaking to assemble all that information and then perform the analysis. So we will be doing that. It's just we want to wait until we can do it and get as definitive a word as we can. If we would have tried to do it within 3 months of the law going into effect, obviously that's too short of a period of follow-up, and people would have been critical of it, even though it would have taken an enormous amount of work to do. So we will be doing it.
Great. This question, why do you think there's been such an increase on those in pretrial, quote, custody versus supervision statewide since the FTA? I think they said FTA, I think they mean PFA launch.
In terms of the number of people on pretrial supervision,
I think, yeah, they're asking an increase on those in custody versus supervision.
So we're seeing kind of two dynamics. One, there's more people on pretrial supervision, and we suspect that part of that is the fact that it exists now in most counties where it didn't exist as an option before. But I also think that part of it is the natural reaction by the judiciary of, well, I can't detain the person, and I think that they potentially pose a risk, and so I'm going to put them on pretrial supervision. Whereas before the law, they might have said, I'm going to require the person to post a cash bond, and that's how I'll ensure appearance. The issue with the jail populations that we're seeing, where that's going up in a number of jurisdictions, in part is this dynamic of people on pretrial release having a violation or a new charge. And what can happen now is you can be detained. If you're charged with another offense, you can be detained until your case is disposed of. Previously, if that would have happened, an individual would have been arrested on pretrial release. They probably would have gone back to bond court. They would have been ordered to pay $1,000. They would have posted the $1,000 in a few days and been out. So the duration of time in jail is going to be longer now.
Great. I think I can answer this one, but I am, I've taken my Illinois hat off and I'm letting you guys keep your Illinois hats on. This person says, I'm not from Illinois, so this may be a dumb question, and there are no dumb questions. I'm glad you asked. But it says, can you please explain what you mean by supervision without conditions versus with conditions?
Uh, what we mean by that is conditions like supervision plus GPS monitoring, supervision plus referral to substance abuse treatment. Those are the conditions. We understand that being on supervision is a condition of release. We're saying supervision plus other things that might be ordered by the court.
All right. And then the next question is related to what this person is calling like a dual supervision, meaning that they're on both probation and pretrial at the same time. So perhaps they started on probation, picked up new charges. Now they're on pretrial supervision as well. Do you see this happening a lot, or do you have any kind of data about that?
We've looked at it a little bit in terms of our analyses to determine which cases are likely to be detained or have detention sought. I'm blanking on the percentage, but we have looked at what percent of people were on some other form of supervision. It's the top two are usually they're either on probation or they're on parole supervision. It's not most of the cases, but if they are, that obviously increases the likelihood that detention's sought and detention's imposed.
And then last question we have, although we do have a couple more minutes, so if anybody has been holding any questions, please, you got another minute or two. But this is the last one we have so far. Is the first appearance typically held after a formal filing of the charges by the prosecutor, or is it held with only probable cause information from law enforcement?
For the most part, I think it's when a case has been filed.
Yeah, I think it's after charging.
Yeah.
Yeah.
That's what I would say too.
Yeah.
And just to be clear, I worked in Illinois for 25 years before I came here. Okay.
I can tell you how it works in Cook County. It's the largest jurisdiction. It is a two-part process. It goes through felony review, who reviews it and determine if it's going to be charged. And then it's passed off to a group of attorneys who determine whether or not there's going to be a detention petition filed. So in Cook County, it's a two-step process. One, felony review to file charges. Two, a separate set of attorneys who determine whether or not there's a petition to file.
Very good. Thank you. Hey, we got two more questions while we're waiting. Do you anticipate that the difference in the detention rate in urban versus rural parts of the state will be used by some so that defendants are treated differently depending upon where the individual may be arrested or charged?
I'm sorry, do you mean geographic disparities in, say, petitions and detention, or is there something, a difference in treatment and?
I'm not certain. I'm going to guess they mean that will the geographic disparities be brought to light? I'm not sure. Maybe Don, if you're still on, if you could clarify that and we'll move on and come back. Let's see here. Next question. Mike, I also don't understand your question.
I'll answer though. I think the one about the rural distinction, at least what we're saying is that there's whether or not you're petitioned for detention or whether or not you're detained varies from county to county. That's the case with this. It's the case with sentencing, right? There's a localized dimension to these decisions. Sometimes, from what we've heard from stakeholder interviews in rural jurisdictions, they know the defendant very well. They know the defendant's family. They know all the circumstances that are going to go beyond what may be, the obvious things from the charges. Some of it also is an issue of resources. So the fact that detention is sought less often and imposed less often in rural jurisdictions could be because they just don't have the resources to seek detention as often as they might wish to, right? Because they can't abide by the time limits. They don't have a defense attorney that's available, those kinds of things.
And on that rural clarification, Don indicated he thinks that it would be both, that it is treated differently in different areas of the state.
Yeah.
The question on whether you have any thoughts on Saturday court or over conditioning. So two very different things, I think, but
You mean the necessity of having Saturday court? I think I mean, one thing that we do find, and we showed that chart that shows how infrequently detention hearings are occurring in rural parts of the state. We heard this before the Pretrial Fairness Act went into effect too. It was just that the lack of resources combined with the lack of cases led to just really ad hoc and infrequent hearings. I think in some parts of the state, there's probably a necessity for Saturday court for detention and conditions hearings to happen on the weekends. And in other parts of the state, there's probably not much of a necessity for it. So I think in places like Cook County or maybe Rockford, Peoria, where we're seeing a lot of cases, and in some of the collar counties, I think there's probably a necessity of Saturday court. Dave?
Yeah, and I think in the smaller rural jurisdictions, the issue is if we only have one case, can we really open up the courthouse? Do we have the staff and everybody to assemble to hear one case? So rather than having weekends, they only do it during the weekdays. And that's most counties. Most counties do not have weekend hearings. It's only the large urban areas, to Don's point. They almost have to, otherwise Mondays would be, overwhelming to them. So.
I have one that I was just clarifying in the chat, and I think I'm right, but just to clarify here, they said they were not clear on the reason why some counties are not participating. Does each county decide if they have their own pretrial program? And so I clarified that I know that pretrial services is throughout the state of Illinois, all 102 counties. And then I believed that basically you're reporting on the jurisdictions from which you have data.
Right. And the other thing too, I don't want it to sound like when we talk about how it's being implemented differently in each county, I don't want it to sound like counties are deciding whether or not they're going to follow the law. The law has an extremely large amount of discretion that it affords to the prosecutor to seek detention, and then the judge has to make a determination in each case if they're imposing detention. So that's why we see a lot of the variation in how the law is being implemented. It's just those differences in how they exercise their discretion, where there is discretion allowed under the law.
I think the same is true about citations as well, whether or not a law enforcement is going to issue a citation or make an arrest. I mean, we're seeing those differences across the state too, in the number of people booked into jail. And while that hasn't really changed in some jurisdictions because they still rely on the jail for fingerprinting and to arrest everybody and bring them to the jail to collect that information.
Great. Last two questions, and then we'll wrap up. Have you seen technical violations going up since more people are now in pretrial supervision?
That we haven't delved into. I assume you're talking about violations of the pretrial conditions. We haven't delved into that yet.
Okay. And then Mike clarified his question. Do you have any recommended tweaks locally or statewide that you think would improve the PFA's impact on the system, the courts or defendants, et cetera?
We're not policymakers. The only recommendations we'd make is around data.
Better collection of data so you can actually track this stuff better. Yeah.
In all seriousness, our goal is not to tell practitioners or policymakers what they should do. It's to provide them with objective empirical information that they can then make policy determinations. So if we conclude that people that are charged with non-detainable offenses have higher rates of failure to appear or new criminal activity, that's up to the policymakers to consider as they reflect on changes to the law. So,
but I think to Dave's point, I mean, to understand the impact of this law requires a great deal of data and timely data. And I think if anything, we would recommend ways to improve that for collection at the state level and for local jurisdictions to be able to look at it themselves on a more timely basis.
With that, we'll wrap up. And I will say that is, other than you're just outstanding people, that's one of the main reasons that I have always enjoyed working alongside you, is that you don't claim to be policymakers. You're just trying to honestly report what's happening. And we are grateful for that. So, so thank you sincerely to both of you, to Dr. David Olson and Dr. Donald Seaman from Loyola University. Thank you all for being here with us today. This was a wonderful time for us to be together and to learn. I did put some resources in the chat just to draw your attention there. There is the survey. Please complete that so we can get feedback for additional webinars in the future. We also have our next webinar in December that is scheduled for December 10th. I put that in there. It's about Denver's model for time-limited supervision. And then as well, we have a special election going on right now. That voting is open right now. So I put all of those links in the chat. You can also find that information on our website, and then I'll be sending out emails as well. And other than that, thank you all for being here today, and have a wonderful rest of your day. Thank you.
Thanks, everybody.
Thank you.